Hi, I'm Sarah Everhart, a legal specialist with the Agricultural Law Education Initiative, and this is a video about defenses to premises liability and ways to limit liability. The first defense to premises liability that I'm going to talk about is assumption of the risk. Assumption of the risk is grounded on the theory that a plaintiff who voluntarily consents, either expressly or impliedly, to exposure to a known risk cannot later sue for the damages incurred by exposing themselves to that risk. Basically, the law does not impose liability on the possessor of land if a visitor ignores obvious risks. This defense applies when a visitor was aware or should have been aware of a risk and voluntarily encounters the risk and then is injured as a result. This is why it's very important to label dangers at your property, so you can later prove that the person who was injured ignored the risk that was clearly labeled. For example, a no trespassing sign or a label of hazardous chemicals on a building, that sort of thing. A way that is very easy to prove assumption of the risk is if you can prove an expressed assumption of the risk when someone signs a liability waiver. If you have a signed liability waiver of someone where they expressly assumed the risk, this is a wonderful defense that you can use. Another defense to premises liability is that of contributory negligence. Contributory negligence is an affirmative defense to the negligence claim, and if it's proven, it's a complete bar to recovery. Contributory negligence is the neglect of the duty of care we all have to observe our ordinary care for our own safety. Maryland is one of only 4 states and the District of Columbia that still recognizes the doctrine of pure contributory negligence, as compared to comparative negligence. Contributory negligence means a plaintiff's own negligence played a part in causing the injury, and that it's significant enough to bar the plaintiff from recovering damages. Your classic contributory negligence example is if a visitor to your farm sees that the barn floor has a large puddle of fuel oil that has leaked from a tractor. Despite seeing it, they walk through the puddle towards the back of the farm, perhaps to look at a piece of equipment. And it's now time to exit the barn, and they again choose to walk right through the puddle of fuel oil. They slip and they injure themselves. The visitor obviously was negligent, and this contributed to the injury. So this is a good example of where you could invoke the defense of contributory negligence and hopefully avoid liability for that injury. What are some simple ways you can limit liability on your land? The first and easiest way is just to do regular inspections of your property. You should be regularly inspecting it and taking note of any dangerous conditions, and obviously then eliminate those dangerous conditions to the greatest extent possible. It's also a good idea to document your property inspections, to just take a simple note of when you did your last routine property inspection. Another good thing that you can do is use signs, blue blazes, or any sort of instructions to warn people of dangerous conditions, areas where they shouldn't be entering, no trespassing signs, the like. Roping off areas and using fencing can also help. You should also educate and train your employees and/or your tenants who are going to be in possession of your property and could possibly incur premises liability. One important thing to understand in the state of Maryland is our Recreational Use Statute. The Recreational Use Statute applies when you are allowing members of the public onto your property for recreational uses, and recreational uses are defined broadly as including any recreational use or farm visit for educational purposes, including judging of livestock, nature study, and similar activities. If the land is made available for these types of recreational uses for no fee, then the duty of care to the landowner is reduced from that owed to a licensee to a trespasser. So this is a great benefit because your duty of care is reduced all the way down to that of what you owe a trespasser, which is a very low duty of care. It's important that the land is made available free of charge and that there's no products for sale on the land. So this would exclude most agritourism operations, and a customer in an agritourism operation would still be owed the highest duty of care. Things that aren't included in the definition of a fee according to the statute are a share of game, fish, or other products, or a donation in kind. If you have visitors at your farm, such as agritourism customers or school or community groups that don't fit within the Recreational Use Statute, you should consider having these individuals sign a liability waiver to protect yourself. The Agricultural Law Education Initiative has created a sample liability waiver that can be customized for your operation. Make sure, whenever you're using a liability waiver, that you retain a signed copy of the waiver and that you have legal guardians sign on behalf of children. This is a sample of our liability waiver, and this is the link where you can find the liability waiver available. Thank you.